Hi, Michael Kushner here. Welcome back to the podcast, HOA Hell. With me today is my co-host, Senior Associate from MBK Chapman, Sam Kill.
Hello,
Sam,
Mike.
good morning.
Morning. How are you?
I'm fine, thank you. As always, thank you for being here.
Glad to be with you. Thank you.
We talked, obviously, when I told you, I kind of write the outlines for our podcast here, and we talked about doing one on elections, and so that's kind of what we're doing today.
Very important. Yeah.
Okay, so basically, what we're going to cover today is, and this is one of the most misunderstood but important areas of HOA life, and that is how do elections work generally. We're not going to talk today about the timelines associated with elections because they're very complicated. It doesn't lend itself to this sort of podcast type.
It's technical. Yeah.
Right. That's something that would be appropriate for an article that I might write on the timelines associated with the elections for HOAs in California. So today, we're going to just talk about how elections are supposed to work. We're going to talk about basically what do you do if your board is one of those bad HOA boards or HOAs from hell, per the book I've written, that rushes ballots, that you've got inspectors not following or not abiding by the very specific obligations that the Davis-Stirling Act spells out for them. Ballots being mishandled, nominations being mishandled, things not getting out when they're supposed to. It runs the gamut. Elections in the HOA context in California are critically important because if you're one of the 55 to 60,000 HOAs and even more HOA members living in California, at one point or another, there's going to be some sort of vote or election.
Yeah.
We're not going to limit today's discussion to director elections. It's going to account or deal with any kind of vote at all within the context of an HOA. And we're going to cover the basics because the rules that are laid out in both the Davis-Stirling Act and in other parts of the Corporations Code, and they kind of work together, have to be followed strictly. Boards do not get to pick and choose which rules they want to follow and which ones don't, although many try. So that's what we're talking about today, okay? So let's start with how HOA elections are supposed to work, okay? So let's start with the civil code sections that address HOA elections in California HOAs, and that is Civil Code sections 5100 through 5145.
Yeah.
Those are the operative code sections, and obviously there are several different laws within that range, 5100 through 5145, and they deal with all the issues related to how elections are supposed to work, from the duties of an inspector to the timelines, maybe to the necessity of secrecy, to the new electronic voting, which we'll touch on only briefly today because we're going to do a separate podcast on that alone. So let's start with kind of the high level, I call high level 4 pillars. Okay, this is my terminology. I think that there are 4 high level pillars when it comes to HOA elections. And then I'm going to name all 4, and then Sam and I will talk about each one. One of them is the secret ballots. Other one is independent inspectors. Other one is equal access. And the last one is strict notice and timeline requirements. Okay? Those are the 4 pillars of an HOA election. In other words, everything that you need to know about HOA elections falls within one of those pillars.
And they exist for a reason. Transparency, fairness, and making sure that they are conducted accurately and pursuant to statutes and most governing documents reflecting some of the same requirements.
And the bylaws in particular, exactly.
Yeah.
Agreed. The object or idea behind HOA elections, like any election for anything, is accuracy, fairness, and preservation of rights. In order for an HOA to work, that is to be more of a democratic process.
That's right.
The votes have to actually mean something. They got to be real votes, and they got to be what people voted for.
Trust it, and you mitigate the possibility, exposure of risk to manipulation,
as best you
sabotage.
can.
The best you can.
Okay. So let's start with secrecy, secret ballots. Civil Code 5115. Okay. All elections, all votes with an HOA context have to be done by the secret ballot system.
Correct.
What that basically means is who you vote for or what you vote for is known to you and anybody you choose to share it with, and nobody else. Not the board members, not the inspector of elections counting and tabulating votes. Nobody. You or anybody you share with. That's what it's supposed to be.
That's right.
That's what it should be. That's why if your HOA is like most HOAs in California that still use the mail system as opposed to the new electronic voting law, which we'll get to, there's 2 envelopes. You'll always notice that those ballots come in, what you receive in your ballot package. There's a big envelope, and then there's a smaller envelope. And the smaller envelope is the one where the ballot goes into and is sealed. And then that sealed envelope, which does not have your address or your name or your signature anywhere on it or within it, goes into the larger envelope where the return address is your address, your name, and an actual signature. But that's the outer envelope.
Right.
Once that's opened and pulled out, there's another sealed envelope inside. That's the one that contains your ballot, your choice.
Hence a secret ballot reference. Yeah.
Right. So there's not supposed to be any identifying information on the ballot itself or on the envelope that contains the ballot itself.
Right.
When there's a crossing of that line, for example, if somebody's opening the outer envelope and then paper clips it, opens both, and then paper clips them together, we have a problem. You're not supposed to do that because now you're tying an identity to a ballot that's been opened.
Right.
That's what's not supposed to happen. So that's what secret ballot is.
Exactly.
Okay? Talk to me about independent inspectors under 5110.
Yep.
Tell me, just, you don't have to name all, but tell me some of the duties that they have and what they are. What is it?
Certainly. So under 5110, independent inspectors are supposed to be truly third parties that are unaffiliated. These cannot, in other words, they can be family members of, let's say, a board member, a sitting board member conducting these.
That's running. That's running.
That's running. Or,
right.
Yeah. And you can't have someone who, and they're supposed to be impartial. They're supposed to be previously ascertained, and so that there's an opportunity to challenge them. They cannot, again, be someone with an interest in the outcome of these elections.
Right. So, in other words, it can be, well, first of all, let's start with the basics. Every HOA has to select either 1 or 3, not 2, not 4, not 5, not 19. 1 or 3 inspectors. Typically, they go with 1. It's just easier, okay? It can be the manager for your property or a representative of the management company. It can be a member living in the HOA, or it could be a professional inspector or an accountant or anybody else.
Or an attorney.
Or an attorney or anybody, any adult over the age of 18 that doesn't have a vested interest in that particular election or vote or whatever's at. So let's say we're talking about a director election. If you, Sam, were an incumbent board member running for re-election, it couldn't be one of your family members or your wife.
Exactly.
Or you. But if you weren't running, if you were, let's say you have staggered board votes, right, every other year, and you're not running, it could be a family member, okay? So it's not supposed to be, or let's say you're not voting for an election, you're voting for an issue. Here's an example under Civil Code 4600, which covers granting of common area and transforming it into exclusive use common area. If, let's say, the exclusive use common area, the vote being given to the homeowners is whether to allow this gift of common area to exclusive use common area, it can't be the family member or the person who stands to get the exclusive use common area. Right. They can't be the inspector because they have a vested interest in this particular vote. But they could do it in the next director election, right? So it just has to be an impartial person that doesn't have a stake in whatever's being voted on in that election, okay? So now, independent inspectors have a variety of duties. One of them is they must be the ones, and he hinted at this, you have to know who they are in advance. They are the ones that receive the ballots. So when you get your 2 envelopes, you put the small one into the big one, you seal it up, you put your address, you sign your name, and you drop it in the mailbox. It's supposed to be addressed to the inspector, okay? That's what's supposed to happen. The ballots cannot be sent to a member at large unless that member is the inspector.
Correct.
Can't be sent to the board. The inspector is the one that's supposed to have custody of the ballots at all times.
The chain of custody has to be.
Period.
Yep.
Okay? That's important. They're the ones that, count the ballots at the election. Now, they're going to be, it's perfectly acceptable and in fact recommended that they're witnessed while they do their job. And that witness can be anybody, any member or director.
Correct.
Can watch. Okay? We want that sort of openness. They're the ones that open the ballots, unseal those envelopes, and they aren't supposed to do that until the election day. They aren't supposed to do that in advance, okay? They're the ones that maintain custody. They're the ones that, very important, they're the ones that have to make a decision within the proper time frame before the election, and they're the ones that have to make the decision and set what's called the record date. So what is the record date? The record date's very simple. It's the date by which the inspector of elections has determined these are the people in the HOA who have a right to vote in this election. That's what the record date is. Pretty simple. Okay, as of this date, here's who's allowed to vote. Now, there's I would say more important, but I guess they're all equally important. But there's another very important duty that an inspector has, Sam, and I'm sending it to you mentally. Tell me what that is. What have I not talked about yet?
Well, let's talk about the record date, the one you just talked about just now. One of the fundamental duties of these inspectors is to vet and essentially verify the membership, that only members vote in this election, not residents, not tenants, not guests. Right. Now, there's one caveat to that. Members who are duly vetted as members of the association, who are eligible to vote, they may designate a proper proxy, meaning who can vote in lieu of them submitting their
If they're
own.
not available, they're going to be out of the country or in the hospital or something.
And that proper proxy is essentially another member within the association who can be designated by this absentee member to cast their vote on their behalf.
Now, you said something, and I want to make sure people didn't miss it. Unlike a normal corporation where I can designate any adult to vote for me as my proxy, anybody I want, you said it has to be another member.
Correct.
You said that on purpose, right?
And that's referred to as a proper proxy.
Okay.
Yeah.
So you can designate proxies to vote on your behalf, but they have to be another member that's entitled to vote, okay? And that's also the duty of the inspector. But the more important part was the part he said right before the proxy, which was you have to be a member.
Yeah.
You can't be a tenant. You can't be a spouse of a member unless you're on recorded title. End of story. You've got to be on recorded title by the record date to be able to vote, period.
Just to illustrate by example real quick, we've had instances in 55-plus communities where a non-member caregiver has attempted to cast a vote, and they've been deemed ineligible.
You're right.
Yeah.
We have a case, and I don't know if you're handling this or somebody else is. Oh, no. I have one of our senior associates. I have Jess handling this case. We have a case right now where the manager, the management company for this association, allowed a tenant to cast a vote. Tenant had lived there for 2 decades. It was actually pointed out by one of the board members that was watching the election, watching the count, pointed it out, and this ignorant manager said, no, it's okay. They voted in the past. It's unbelievable. And she wouldn't stand down. So, I mean, he came to us. He came to us because when he called her out on it, one of these managers that's been given authority that's not legally allowed to be given.
Yeah.
We're actually going after the HOA on this director's behalf.
Right.
Because she has cowed the other 2 directors who were cowards.
I mean, that right there is a prima facie, scenario of a violation of that record date too. Because,
of course it was.
Yeah, because even if hypothetically, just real quick, if this person were to all of a sudden become a member, right? Like they purchased into the community, even though they're a tenant.
After the record date,
after the record, they closed out. Yeah, they can't cast a vote.
That's right.
Yeah.
Bottom line is, only members can vote. And only members can be proxies. That's what you need to know. The next one is equal access. That's governed by 5105, the Civil Code. And what that means is, we're talking about, for example, the best example or the most common example we see is that, let's say an incumbent is running for the board, and the incumbent's going to use the association's clubhouse to have a little mixer or a cocktail hour or hors d'oeuvres to try to usually in bigger associations you might see this sort of campaigning, but is having an event to garner votes and is using the clubhouse, which is an amenity. The HOA has to make that clubhouse equally available to anybody else running as well. They can't say, well, no, you can't use the clubhouse. All right. If they've allowed another director to use it, then anybody running can use it.
Yeah.
Okay. Now, obviously, there'd be some rules: first come, first serve. If I've reserved it for a certain date, somebody else can't come in and say, well, I wanted that date too. That wouldn't work. But you've got to give equal access to the accoutrements of the HOA when it comes to campaigning. You cannot give an advantage to a director by virtue of the fact that they are a current sitting incumbent director.
Right. We also see it with bulletin boards, newsletters. I mean, equal access. You can't give one person unfettered access and prohibit someone else from posting. Yeah.
Same with if the HOA itself controls a website or a Facebook group, as opposed to a privately owner living in the HOA that controls it. But if an HOA controls a URL or a Facebook group or some other social media group and is allowing the incumbent director to post campaign-related stuff for his or her campaign, they have to allow everybody else equal time to do the same thing for one.
Yep.
Okay, so that's very good. Yes, that too. Okay, and then of course there's the strict notice and timeline requirements that are set forth in Civil Code 5115. We're not going to go into the timeline requirements because they're horrifically complex. Okay, we'll do that in a separate article one day because it, like as I said before, doesn't lend itself to, in my opinion, to a podcast. Okay, now these are not optional policies; these are required under the law, and they are strictly interpreted, meaning you got to dot your I's, cross your T's.
Yeah.
You cannot play fast and loose or take shortcuts. Let's talk about briefly, just for the sake of bringing it up for those few people, relatively few people, who live in an HOA that is already ahead of the curve on this, and that's the new law regarding electronic voting. Okay? January 1st of this year, 2025, electronic voting came into being. Controlled by Civil Code 5110 which is part of the Davis-Stirling Act. This is a complicated area because it's new. There are a lot of requirements that are in place to ensure that for any HOA that is adopted properly, the electronic voting requirements, that the voting remains just as secret there, just as equal access there as it is if you were running paper ballots. And so because of the technology issues that are at issue, because there is technology requirements. In other words, whatever system you're using has to be able to do a series of things that are set forth in the law. Because the election rules have to be modified properly,
Right.
proper notice period, all that, and the equipment has to be vetted and all these things. A lot of HOAs just haven't gotten around to completing the requirements yet. Yeah. Not to say that they won't, they will, but it's only been since the beginning of the year, 8-10 months, wherever we're at.
Right.
10 months.
10 months,
so yeah, it's only been 10 months. So a lot of HOAs, relatively speaking, haven't done it yet. But they will. There will be a time in the next couple of years where that'll flip. Okay? So we're going to do a separate podcast episode entirely on electronic voting. So for the purposes of this podcast, I want to very briefly touch on this. Okay? Obviously, electronic voting represents a massive shift, at least in the technological aspects of voting. It's more of a modern take on how to vote. Once this becomes kind of everyday and the technology is vetted and it's easy to use, it will end up being a better system, I think.
Yeah.
Certainly, manpower-wise, much more efficient. Okay, and so because it's going to be electronic. All right.
It's intended to streamline the process and grant greater access, essentially.
Right. But let's just say there are some things that are required under electronic voting, and we're going to leave it at that without going into details. Okay. One of them is, I already said, the voter authentication.
Correct.
The system in place has to have a mechanism of guaranteeing proper voter authentication, just as has to be done now. We talked about that. Okay. Who's a proper voter?
Yeah.
Okay. Ballot secrecy. Mentioned that already.
Yeah.
Has to maintain the same degree or level of ballot secrecy that paper ballots are able to do with a separate envelope system. There has to be a confirmation of receipt so voters know their ballot was properly cast. Right. When you right now put the little envelope inside the big envelope, seal it all up, and then stick it in the mailbox, you are, setting aside the errors that the post office can and do make once in a while. But if you look at the volume of mail that our U.S. Post Office deals with every day, and we're talking, or every year, billions, trillions, right? To be honest, they do a phenomenal job given the percentage of things that actually get lost.
Yeah.
They do an amazing job.
True.
But with almost a decent degree of certainty, you drop that in there, it's getting to where it's supposed to go. That same thing has to be here. When you cast your ballot electronically, there's got to be some sort of receipt process that says, okay, you have successfully voted and your ballot has been sent to the proper place, something like that.
Yeah.
And then, of course, there has to be a mechanism built in for this secure retention of those ballots. Just like right now, the inspector has to physically take custody of those and stick them somewhere secure. Okay? Same thing. All right?
Yeah.
So we'll do that a different time, but just know that it exists. If your HOA has already adopted, one of the relatively few that's adopted electronic voting, then your HOA is ahead of the curve. Good on them. We'll talk about that in the future. Okay?
Yeah.
All right. Next, transparency, access, and inspection rights. And we're talking about homeowner inspection rights.
Yeah.
Let's talk about that. Governed by 5125 of the Civil Code. Okay? Every member or their authorized representative, which does not have to be a member, that could be a lawyer or an accountant, usually a lawyer, okay, has a right to inspect election materials as long as they are not violating ballot secrecy. Meaning, I as a member cannot hire a lawyer or myself go in and demand to inspect both the outer and inner envelopes that came with those outer envelopes. Because by definition, I would immediately. So in other words, I can't say, give me the opened outer envelopes and the opened inner envelopes, which is still in the outer envelopes, and I want to look at both. Can't do that because I would now know who voted and what they voted for.
Exactly.
So, but I have a right to see
that the process was conducted properly.
Right. I have a right to see who voted, but I don't have a right to see what they voted
how
for.
They voted.
Or how they voted. Exactly. Okay? The law is doing a little dance here. It's balancing secrecy and accountability. Privacy and accountability. That's what it's balancing. And it's not the easiest thing in the world to balance, so it does the best it can. But I actually think the rules that are in place in the Davis-Stirling Act for this and in the Corporations Code are actually, they make sense.
They make sense.
They make sense. They make sense given the technology.
Absolutely.
Okay?
Yeah.
And that's very simple, right? Okay. Now, let's get to the more important part of this podcast, and you're going to help me some more here, Sam, okay? And that's the most common election violations that we see in our practice. These are the frequent violations that bad California HOAs or HOAs from hell engage in to thwart or mess with the system that we've described so far, okay? Give me an example.
Well, there are many. One example is an improper designation of an inspector. Let's say they designate someone who is an actual interested party of someone running or has a vested interest in the outcome of the elections. Exactly. That's a huge one because that right out of the outset it's poisoning the well, so to speak.
That's right. So the appointment of an inspector who is either not qualified or shouldn't be serving based on the rules we described. I agree. That is a very important one, and we see that. We see that a lot. We saw that in the example I'm giving. In this case, the board is aware that this manager allowed a tenant to vote, and they didn't do anything about it. Only one director objected. But the bell rang.
And now the rest of them are on notice. So they have a
so by the way,
we're
challenging that election.
Yeah, absolutely.
Now, we'll drop the challenge. We're challenging in the sense that we've demanded to review the ballots or to see who voted and to see what the count was. Right? If the allowing of that tenant is not going to have any change on the results, we're not going to file anything in court to challenge the election because there's no point. Okay? We're still petitioning, we're arranging a recall of the entire board, including our client, because if we get a new board in place, the first thing that our clients, if reelected, or that the new board is going to be tasked with is firing this manager.
Right.
Okay? Which, by the way, another issue we're going after is her contract's completely illegal. Okay? She's the sole owner and manager at her own management company. She's not one of the big ones. And she is a hack in the best sense of the word. And I can say that because I'm not giving her name. Okay? Good. But her company and her are what we call in the business the blind leading the blind. And that's being very nice because I actually have other adjectives that I use in private. Okay?
That's rough.
Because I've rarely seen somebody as incompetent, corrupt, and just nasty as this particular individual. Well, it's actually fascinating how anybody could end up this way, and I wonder what this person's childhood was like, because it must have been like Carrie.
Well, it's a disservice to her association clients. Let's just say that. Yeah,
unfortunately.
Well, another one here is violating the secrecy aspect of it. If the ballots are not properly, maintained, but also, let's say the inside envelope that's supposed to be secret, the secret ballot, is actually labeled or identifies
or has a name
who's
or an
casting
address.
it. Exactly.
Right, exactly.
Right.
Or the ballot itself does.
Right.
Now, typically that doesn't happen because hopefully the law firms that represent the HOAs are actually preparing the ballots.
Right.
In this particular one we've been talking about, which is why I chose her as my example today, this management company, one other thing that we're challenging that's gone wrong is when she was acting as the inspector, she granted custody of all the ballots to a homeowner outside of her presence. They were being stored in this member's garage.
Can't do.
Okay?
Yeah. Violates the custody. Yeah, chain of
absolutely
custody.
does. Our client pointed that out and was overruled again by her. Okay? Even though the code is crystal clear on the topic.
Yeah.
So secrecy is best maintained by the inspector following one of their obligations, which is maintaining proper custody. The inspector is supposed to be indifferent. If that person is maintaining custody, chain of title to those ballots, there's less of a chance of the secrecy aspect being compromised. To me, that's obvious.
Any tampering, yeah.
It's a priori, right?
Yeah.
Okay. Another one is, well, refusing equal access.
That's a big one.
To the HOA-controlled website or Facebook or Clubhouse or mailing lists or whatever it is.
Right.
Okay? That's one of them. Here's one that we see, very illegal, is ignoring the quorum requirements set forth either in the governing documents or by default in the code if not stated in the governing documents, which almost always is. Those quorum requirements have to be followed strictly. What's a quorum? A quorum is the number of eligible voters that have to show up meaning either cast a ballot or show up at the meeting to cast a ballot.
Participate, yeah.
There has to be a minimum number set in order for that election to even go forward.
Right.
So, for example, if a quorum in your HOA happens to be the default, which is a majority of, so let's say your HOA has 100 people, a quorum will often mean 51 minimum, because it has to be more than 50%. So it can't be 50. 51 show up, meaning a majority of a quorum could win an election or win a matter if 26 of that 51 voted a certain way. So 26 out of the 100 could control that election because the quorum showed up, a minimum quorum showed up, and the majority of that minimum quorum voted. Okay, so that's what a quorum is. You've got to follow quorum requirements set out in the governing documents or the code, whichever controls. And we talked in another podcast about voting thresholds.
Right.
You have to also look at the voting threshold. The example I just gave was something got effectuated because it received a majority vote of a quorum, 26 out of the 100. Because 51 showed up to vote, that means 49 didn't. So the majority of that 51 is 26. Right. 26 carries the day. Unless the code says, or governing documents say, whatever is at issue in that election requires a majority of the membership, not a quorum. Not a majority of those entitled to vote that appear and are entitled to vote,
right.
Which would be another way of saying a quorum.
Yeah.
So you got to look at the fine language to see what the threshold is. But that's a topic for another day. Here's one more, last one. Mishandling or prematurely opening ballots.
Yeah,
you can't do that. Ballots have to stay not only in the custody of the inspector, but stay sealed.
Correct.
Until the appropriate time.
Yeah.
And if they're open prior to that, who knows who's looked at them? There's no way to know whether or not he or she, the inspector, or whoever else the inspector might have wrongfully given the ballots to, didn't show everybody. You have no way of knowing unless it stays sealed. So you can't open them prematurely.
Correct.
So those are all things that bad HOAs engage in.
Indeed.
Okay. And then there's, I guess, one more that's kind of a catch-all. It's a big one. Is HOAs that kind of ignore all the timelines or ignore somebody that wants to have their name added to the ballot. They ignore the nomination procedures and they kind of favor specific people or incumbents. You can't do that. You got to be fair. Okay. So moving on to the next section. Now it's time to challenge something. So let's talk about what happens. What are your options? Small claims versus Superior Court. Okay. And this particular section is where we're going to talk about the difference between what the law allows you to do and what is probably a good idea to do, okay? So California law, specifically the Davis-Stirling Act, and we'll get to the sections in a second, 5145 being one of the examples here. California gives homeowners, when it comes to disputes regarding elections and election procedures, gives California homeowners a choice between small claims and Superior Court, okay? So let's talk about small claims court. And make sure, Sam, if I forget to mention, make sure we talk about the one part of this statute that is unique in all of the Davis-Stirling Act when it comes to small claims court. Okay?
Yeah, absolutely.
Okay. So in the vast majority of cases in California that are appropriate for small claims, that are within the jurisdiction of small claims judges are not empowered to issue declaratory or injunctive relief. They are empowered to issue money damages. That is the universal rule, but it is an exception that doesn't apply to the 5145 of the Civil Code provision in the Davis-Stirling Act, where small claims judges are actually empowered to give injunctive or declaratory relief orders. It also exists, that exception, in context of a 5200 document demand,
right.
but we're not talking about that today.
Yeah.
Okay. Now, let's talk about small claims court, okay? Because small claims court certainly is easier, quicker, cheaper, and by definition, you don't bring an attorney with you to argue your side. There's no discovery. There's no depositions. There's none of that. You get a trial date relatively quickly, and it's boom, bam, done, you're over, okay? So when in doubt, and all things being equal, if you're dealing with a simple matter, small claims might make sense. But remember, I start out by saying the code gives homeowners the right to use either one of those when it comes to an election dispute or procedure, regardless of its complexity. And that's where my advice to you is going to be a little different than what the law allows. Okay, so if I'm a homeowner who wants to challenge a dispute and I sue in small claims, I can sue for example, HOA's failure to hold an election that's required. I can sue if the election was not done properly, if the inspector allowed tenants to vote and that would have made a difference. I can sue for all of those reasons in small claims court. Okay? And here's that unique part that I didn't want to forget. Unlike every single other code section relating to small claims court that I can think of anywhere, just off the top of my head, I can't think of another section in the civil code that has this exception. You are entitled, if you win in small claims court for an election dispute, to get added to your award the cost of attorney's fees that you incurred in consulting with a lawyer about filing the cross-claims case. The lawyer can't come with you to small claims court and argue the case because lawyers can't represent people in small claims.
That's right.
But if the lawyer's consulting with you before you went forward, helped you prepare the small claims case, helped you write a brief, helped you prepare for it, even use their service to effectuate the filing and the serving, you can get all that back. That is unique.
It is unique.
It's powerful too.
Yeah.
Okay? But small claims courts have realistic limits. Again, we're not talking about a legal limit here. We're talking about a realistic limit. It is difficult for small claims judges to monitor a post-trial day order. For example, if a court awards at a small claims trial or awards damages to you, they've awarded the damages. Maybe they took it under submission and awarded it a week later, but they awarded it based on the trial date. Problem solved. That's easy. But if they also awarded, let's say, injunctive relief and ordered the HOA to hold an election by this date in the future, somebody has to police that if the HOA doesn't follow through. And the small claims courts are not set up very easily to do that. There are no motions in a small claims court.
Right.
There are no intervening briefs that you file. It's just a small claims case. It's called a claim for relief, right? So the mechanisms established in small claims are simplistic on purpose because there are no lawyers involved. It's very difficult to have a mechanism that a judge could take a follow-up motion, for example, have you come back and say, hey, you ordered them to comply by December 5th and it's December 20th and there's been no election.
It's a court of limited jurisdiction for those reasons,
So even though this code specifically authorizes the judge to do that, it's very difficult for a judge to do that. Now, it doesn't mean it can't be done. Judge could arrange that and say, look, if they don't follow, you come to my clerk in person and I'll set up a hearing date. But it's not done through the normal processes. It bypasses the normal clerk of the court in favor of the clerk of his or her courtroom. So it is a very unique proposition. It can be done. But because of those inherent difficulties, that's why the judge's bench book, it's a book that's provided to judges that advises them on how to kind of do things, advises against judges in small claims issuing injunctive or declaratory relief.
That's right.
It doesn't mean they can't. It just advises against it because it's hard. Their calendars aren't even set up that way.
Right.
All judges in the Superior Court have motion times. They have times where they hear trials and times or days where they will hear motions. It doesn't work that way in small claims because there aren't motions. So it can be done, but it might not be the best idea to do it there. You might be buying more than you intended to buy in terms of just difficulty. and getting
I almost
back
think of it
in
as
front
a-
of the judge.
I almost think of it as a partial resolution. It's a quick one, a quick avenue, but limited jurisdiction. And like you said earlier, but just to echo those points, you don't have the law in motion. You don't have ex partes. You don't have contempt hearings. You don't have sanctions. Those tools are all limited to you in small claims.
Right. Now, a judge in small claims can sanction you. Judge can small
Yeah.
claims, can throw you in jail for contempt, and can sanction you, but he's talking about the civil contempt stuff
Yeah.
when you don't abide by court order. Now, they do have that power. They are judges. They're
They do.
sworn judges. If there is a judge that has experience doing this and has set his or her courtroom up to do it, then it'll work fine.
But it's not
most
routine.
judges
Yeah.
don't, and it's not routine. That's
Yeah.
the only point we're making. So that leads us to Superior Court. Superior Court is big boy court. It's regular court. Okay, it's more expensive. Without a lawyer, you're in over your head right off the bat. I don't recommend anybody represent themselves in a Superior Court because you don't know the rules of civil procedure. You don't know the civil code. You don't know how to write briefs. ChatGPT is going to give you terrible advice because it'll hallucinate like crazy and give you cases that don't exist. And each court, you don't understand what local rules are, what local rules are, what rules of court are. You just don't know those things. You're not equipped. Our system is set up that way. It's unfortunate, but that's the way it is. So, which is good for us in our profession, but it is what it is. Okay. Bottom line is, Superior Court, you need a lawyer. It's a much longer process. It could be a few years before you ever get to trial. It can be very expensive. There's a lot of moving parts, but those courts are equipped to handle anything and everything under the sun. Okay? So I think of small claims as a quick repair shop when I want something simple. Hey, judge, I'm entitled to statutory sanctions for this. If I can prove this happened, I get an order, write them a check. Done. Easy. They can do that. But maybe I don't want to do it if I need the court to be monitoring the behavior of the HOA to follow through with injunctive or declaratory relief. Okay? Last thing. Let's talk about some strategic tips for homeowners. If they suspect or see things going on related to elections that are not kosher.
Yep.
Okay? These are ways to protect your rights. Okay? So, you, as a responsible homeowner, if you know you live in a bad HOA or you suspect your HOA engages in shenanigans related to elections, is monitor the timelines.
Yeah.
There are some websites out there that actually have pretty good election timeline clocks. You plug in the date of an election and it spits out automatically a list of all the dates by which nominations have to be sent out. Nominations have to be received. The record date has to be set. The inspector has to be chosen. Things have to be mailed out. So if you know that you've been told by your HOA that the election's on October 23rd, you plug that into one of these online calculators and whoosh, all these other dates spit out. So do that and then monitor. Make sure the dates are being adhered to. If nomination deadline is September 4th, make sure that your HOA set the nomination deadline by that date. Okay? Don't let them violate those timing requirements because those are required. Again, all of these election procedures are strictly interpreted. Okay? Give me another one. Look for what? Documented irregularities. What is that?
Well, I mean, from the ballots, the way they're cast, to notices that go out, to, I mean, obviously there's crossover, but also looking at...
well, let's talk about the ballots. Let's say you submitted yourself to nominate. I want to nominate myself to run for the board, and then the ballots go out and your name isn't on there.
Omitted, yeah.
That's a problem, guys.
That's a huge problem, yeah.
Because you have a right to nominate yourself or nominate somebody else. You have a right to run.
Correct.
Okay? And if they omit and by the way, when a nomination, if somebody wants to nominate themselves or somebody else, and that person is rejected, that triggers another deadline, an IDR deadline.
That's right.
Related specifically to the appropriateness of denying that person the right to run. So that date has to be triggered as well. So if you open up the ballot and your name isn't on it and you submit it timely, your nomination of yourself to run, then your name is supposed to be on the ballot.
Right.
And if it's not, you probably also didn't get your IDR requirement. Right. Because otherwise you wouldn't be surprised that it wasn't. Right.
And the intent there is for a swift resolution.
Exactly.
And regress.
Yeah. In other words, if they say, no, you can't run for this reason or that, you can't run for the board, okay? You're entitled to, and they're supposed to offer automatically and set a deadline for a chance for you to meet with them to explain why and for you to be heard, period.
Yeah, due process.
Okay, right. You have a right to, you want to make sure you request information about the inspector. Who's the inspector? What's their contact information? Have they ever done this before?
Yeah.
And you can interview. You can write an email to the inspector. Say, hey, how many inspections have you done? Is this your first one? Are you familiar with the code? You have a right to vet a little bit, not harass, no, but to ask a couple of reasonable questions. That's not unreasonable. Reasonableness is a factor here, okay? Pay attention to the 1 year statute of limitations because that goes by quick.
Yeah.
To challenge an election, the propriety of an election, you have 1 year for the date of the election.
Right.
1 year. You could have the most fraudulently conducted election in the history of the world, and if you wait 370 days, you're out of luck.
And by the way, I'm not sure if you mentioned this, but the inspector is supposed to keep the records of the election for at least 1 year.
We didn't mention it yet.
Which corresponds with that challenge.
Right. We didn't go into the details about of what the inspector's obligations are. I did that in an article that on my website. You'll find an article about the inspectors of elections detailed duties, and one of those is what he just said, what Sam just said, which is that. Well, go say it again. It's your baby.
Well, they have to keep the ballots and the records of what's logged as the votes cast for at least 1 year.
Yeah,
now they may do it longer,
right?
And that corresponds with the 1 year challenge as well. Yeah.
So in other words, remember you have a right to demand to look at as long as it's preserving privacy, secrecy.
Correct.
You have a right to look at the balloting documents and everything. So in order to protect a person's due process right to file a lawsuit within a year, the inspector obviously has to keep that stuff for a year. Now, some inspectors will keep it indefinitely until the garage fills up or they've got boxes and boxes and boxes. That's okay too. They can keep as long as they want, but they have to keep it at least 1 year. You can't shred them the day after. We had an election a few years ago. We represented a client in a very high-end community. The houses went from 5 to 15 million apiece. And this inspector shredded we asked for him 2 months after the election, and the inspector actually said that she had shredded them. So, yeah, I mean, you just can't do that. It's a problem. Before you file, whether small claims or Superior Court, contact an experienced HOA attorney like us at MBK Chapman. Make sure that the grounds upon which you're challenging the election or the issues you have are actually valid issues. Because what you don't want is to be one of those people that goes and makes a big stink, and it turns out you're the one that's wrong. Okay, that wastes resources. It wastes for everybody, and there's no point doing that. You want to do it right. Okay. Yeah. Bottom line: elections in California, when it comes to HOAs, are supposed to be fair. They're supposed to be secret, and they're supposed to be in compliance with a very, very clearly stated set of rules that have to be followed strictly. If your HOA is violating any of those rules, is engaging in shenanigans that threaten the sanctity, secrecy, or I guess the sanctity is a good word for it, of a particular election, you have to stand up. You have to prevent it. You have to fight. You can't allow that to continue because it's too important. Okay? So be mindful. Know what your rights are. We've described them. You have a right to inspect. You have a right to challenge. You have a right to sue. You have a right to get your attorney's fees back, regardless of whether you sue in small claims or in Superior Court, which is a unique situation. And I think the law, Davis-Stirling Act in particular, does a good job protecting homeowners when it comes to elections. Courts don't like elections that are run by crooks. They do not like that, and they will come down like a ton of bricks on a bad HOA hellish board. So be mindful, pay attention. If you like this episode, please hit the like button. And if you haven't already subscribed to our channel, HOA Hell, please do so. If you want to leave a comment, as always, we love to hear. Until next time, have a wonderful day.